Hey, all present, I didn't fully on with the justice and bail score. Now stay in the corner within the Commonwealth. Draw near, give your attendance, and you shall be heard. Let's say the Commonwealth of Massachusetts, this court is now open. Please be seated. Good morning, Your Honors.
Morning. Good morning. I'm Justice Meade. With me on the panel today are Justice Hodgens and Toone. We'll be the panel for 5 out of the 6 cases. After the 6 cases called, we'll reconstitute the panel at that time. If you've been here before, you know that we've read everything. If you haven't been here before, we've read everything. My advice is to get right to the point. Each side gets 15 minutes. You needn't use all of your time. With that, I'll call the first case, 24P147, Commonwealth versus Columbo. Mr. Garland.
Good morning, Your Honors. May it please the Court, Keith Garland on behalf of Mr. Dominic Columbo. I'm going to suggest here, in Mr. Columbo's case, that he did not receive a fair trial. The first issue I'm going to talk about is I'm going to suggest that the judge erred in failing to hold a hearing prior to discharging the juror. And in that standard, because it's a constitutional issue, because improperly discharging a juror is a constitutional issue, I'd suggest because the defendant has a right to a fair trial, no prejudice is required as a result. A constitutional question is preserved. When a constitutional question is preserved, the Commonwealth has the burden to prove whether it was harmless beyond a reasonable doubt.
Did you make a constitutional objection at trial?
I mean, the word constitution was not used, no, constitutional. The objection, the discharging the juror was objected to twice, and defense counsel laid out what he suggested should happen, put the jury over till tomorrow, and then we can see if she's able to come in tomorrow. Again, what happened here...
He didn't request a telephone conference, though.
He didn't physically request a telephone conference, no, but he objected to the discharging of the juror and the way it was done, and that didn't include a telephone conference, a Zoom conference. It didn't include anything. And I'd suggest that he did object on 2 occasions, and on 2 occasions the judge noted his objection. It's on trial day 7, pages 3 and 4. And again, he laid out, the defense counsel laid out exactly what he thought should be done, and it can be inferred that a call would have been made the next day to see if she was able to come in. And with the Zoom capabilities that we have in all the courtrooms today, or a phone call could have been done, because then you could have asked the question of, or let the juror know whether it has to be a personal issue that is the cause of you not coming in. It can't be have anything to do with the jurors or how you feel about the jurors, or if you're a lone dissenting juror. So I'd suggest that the constitutional error was preserved and that you don't have to object saying that it's a constitutional. As you well know, the discharge of a deliberating juror is a sensitive undertaking and is fraught with potential error. Great care must be taken to ensure that a lone dissenting juror is not permitted to evade his responsibility. And I suggest that
there's nothing in the record to indicate that she was the lone dissenting juror, or that they're even at an impasse.
There is nothing in the record, Your Honor, and I suggest the reason for that is because they didn't hold the mandatory hearing with the juror. Tission says that a hearing must be held with the juror, and that's when you can inform the juror that it has to be reasons personal to her, and that it can't be anything to do with deliberations or how you feel about
Well, let's
the other
walk
juror.
through this for a little bit. What if the judge did do what you're suggesting and at least made a phone call, and maybe the person just doesn't pick up the phone because, she's in bed, suffering from this illness? What then?
I suggest you'd have to wait and try again. And because the facts of the case, so there's Commonwealth versus Hawley, where the juror left the day before in an ambulance. They just suspended the jury for the rest of the day. And then in the morning they called and they talked to the juror, and the juror said, hey, I was at the hospital, I was determined to have the flu, I have a fever. doctor said I can't come in for 7 days because I'm contagious. That was fine. The counsel was present. That was considered fine. But I'd suggest to you like calling in sick is one of the oldest tricks in the book for getting out of doing something you don't want to do. I'm pretty sure almost everyone in the world has pretended to be sick at one point to try to get out of something. And during deliberations, a juror may only be properly discharged for reasons personal to that juror, as I had mentioned. And again, to make that determination, Tissione says a judge must hold a hearing with the juror in question. So I'd suggest that if they can't get a hold of her, they have to try again.
But what about the Haywood case that says the juror does not have to be present?
In the Haywood case, I have, if I may just have a moment. I did lay that out in my brief. In the Haywood case, the fact that the discharged juror's illness was confirmed by an attending doctor in the presence of counsel, that's what the Haywood case. So there was evidence that the juror was sick. Here we just simply have an individual saying they were sick. And again, you have the 11.5 hours of deliberation that happened with the original jury, and then a new juror was after the hearing in the morning at 9, presumably started at 9 o'clock. They go through this, how they're going to discharge the juror.
Right. I mean, that's an after the fact inference that you're making, and it may, may be a reasonable inference, but I guess it seems like your position initially is that there has to be a hearing where the judge, if the juror just sort of reaffirmed the things that she had said in the voicemail, that would have been a sufficient reason to excuse her. But you're kind of saying the judge had to make some kind of effort to find out whether she was not telling the truth. Is that
Exactly.
there has to be some kind of like questioning her credibility or something like that? Does the case law actually say that there has to be this kind of inquiry into the veracity of what she's saying as opposed to just determining the basis for why she's not showing up? I
mean, obviously face-to-face would be best, so Zoom would be best. Because you'd be able to read the demeanors of individuals, but a phone call is sufficient, especially with counsel present, because then they'd be allowed to ask the judge or to inquire into different things. None of that was done here, and the case law is very specific, especially with Tissione, that says the judge must hold a hearing with the juror in question. And when the judge discusses with counsel what the juror said, he said it sounded like she had serious GI symptoms, which I don't understand what that means, but then he went on and stated, I think, or I believe that's what she said, I didn't take notes. So again, there's no findings were made. He simply listened to a voice message once. The defense counsel did not hear, or the Commonwealth did not hear the voice message. And again, they could have called, they could have at least tried calling, and I suggest that because of this is a reversible error in and of itself.
But what about at the beginning of the trial, where the judge is still sort of operating under some COVID protocols where he's wearing a mask, he's encouraging others to wear a mask if they want to, and he's told jurors, he's expressly told them, if you're sick, don't come in. So he's kind of committed to that protocol, hasn't he?
I agree, but there has to be proof that she's sick, because he expressly said that there was no mention of COVID. She did say she had a fever. But again, what has to be said to the juror is this has to be a personal issue. This cannot involve anything to do with the deliberations or with any of the other jurors, your relationship with the other jurors. That didn't happen here. If that phone call happened and that was said, and she said, no, I'm sick, I have a fever, game over. We're not here. But that didn't happen. Nothing happened. It just was a simple voice message. No one spoke to this juror. And again, with 11.5 hours deliberation and a new jury gets impaneled, 2 hours later they have a verdict. I suggest that's an inference.
What about a situation where we have a juror who's just so ill, but not ill enough to go to the hospital, just ill, and let's say a spouse calls in, and says, geez, my wife is very sick, she's not going to be able to come into court today. What does a judge do in a situation like that?
So that I would suggest would be held under Commonwealth versus Perez. Juror went missing midday, judge dismissed the juror, sent the others home. Counsel was not present when he dismissed the jurors. The next day, the defendant came back and objected to the juror's dismissal, and the court held there was nothing in the record other than that the juror was sick, and that a hearing was not held, and it was a reversible error. And I suggest that's exactly what happened here. And that's, Commonwealth versus Perez is cited in my brief, and it's almost to the T exact.
So in my example, who would the hearing be with? The hearing be with the spouse, or or you drag the sick spouse out of bed?
It could be with the juror's spouse, sure. I just, as in Perez, they didn't do anything. They heard the juror was sick, discharged the juror without counsel present. I mean, here counsel was present, but there was no hearing, and there was the finding that no good faith basis was put on the record. And I suggest that's the same exact as we have here, and it goes to the Hawley case. Again, they asked counsel to be present. They phoned the individual. She said she was sick. The doctor said she was sick. That was enough. It wasn't reversed. Nothing was done here, and I suggest that it's a procedural error and alone requires reversal. And I'd also suggest that the jury failed to begin anew by leaving those questions and answers in the deliberation room. Again, this is not a part of the original instructions where all the jurors were present, and it's just an addendum to those instructions. This actually shows exactly what the jury was focused on. They're focused on the act, they're focused on recklessness, they were interested in the video of the truck, and they were interested in the definition of very likely. And I suggest that this having those questions and answers, shared with the new jury the questions and what the old jury was faced on. So I suggest that the province of the jury was invaded. Now, moving on to the verdict slip, I understand there was no objection, so it's a substantial miscarriage of justice. And I'd suggest that when there's general verdict slips, when there's multiple forms or culpability or forms of guilt, so here, operation under the influence, serious bodily injury, there is operating under the influence, 0.08 per se, reckless negligence. And in Commonwealth versus Aceta, in cases involving more than one theory, the defendant may be found guilty, but separate verdicts of each theory should be obtained. And then Keevan, jury must be unanimous on the theory of culpability, finding the defendant guilty. I understand that in Commonwealth versus Plunkett, the general rule in the Commonwealth is that there must be a new trial if, as here, given the two theories of guilt, there was a general verdict and evidence supported a guilty verdict on only one of those theories. I suggest the evidence only supports a guilty verdict on the 0.08 per se for the operating under the influence portion of that case, or the OUI. Here, I suggest there was insufficient evidence of the intoxicating
Maybe just the fact that someone's doing, just the fact someone's doing almost 70 miles an hour in a 25-mile-an-hour zone and crashes into a car that's making a turn. I mean, you couple that with all the conditions that were present that night. Isn't there just a chance jurors could infer some level of intoxication from that?
I would suggest speed alone isn't enough. There was 7 police officers that testified that he was sober, not intoxicated, no smell, no slurred speech.
But for on sufficiency, we look at the evidence in the light most favorable to the Commonwealth. So we discount what the defendant's case was. And there's evidence of drinking. There's evidence that he smelled of alcohol at the hospital. We can the jury could consider his blood alcohol content.
The jury can only consider his blood alcohol content under the influence portion if there was an expert, and there wasn't an expert. So they can only consider that if it was. There's also consciousness of guilt too. I agree with that statement, and I'll move on. Again, I'd suggest that there was an error in admitting the blood vials. Because of the lack of authentication, there wasn't a witness that could particularly identify the vial. There wasn't a witness that placed the identifying mark. No one knew who drew the blood, who placed the label on it, who printed out the label, or where the blood went. And the Commonwealth cites Commonwealth versus Davis and that it can be authenticated through circumstantial evidence. And that case involved a video of a shooting. So if they play the video, you see the defendant, you see the victim, you see a shooting, you can authenticate that that's a video of the shooting. Here we don't have that. We just have a picture of a vial of blood, and it's the only evidence that suggests it was the defendant's blood. And then moving on, I'm going to jump to my next to last issue. I suggest that the propensity evidence that was allowed in through the medical records is reversible error and was preserved. So in that, there was portions of the medical records that stated 3 times that the patient endorses daily alcohol consumption. And if
Why isn't that part of the diagnosis and treatment?
If it's part of the diagnosis and treatment, which it could be, because there was other evidence, and I'm not a doctor, but sure, that could be. But again, it's still highly prejudicial in a case like this when they can only focus on that night. They can't focus on, he did it before, he'll do it again. And that's exactly what that says. That if he has a drinking problem, they're going to say, he has a drinking problem, he had a drinking problem tonight, he was under the influence, or he was drunk. So I suggest that even if it was part, it's still highly prejudicial and should have been taken out. But more importantly, there was also details of alcohol withdrawal. That's propensity evidence. That's absolutely should not have stayed in. And then they also overruled an objection. There was 4 pages about learning about alcohol misuse. And the judge himself stated that a serum of 0.41 is consistent, that all these things are consistent.
We're going to have to leave it there, Mr. Garland. Your time is up. Thank you. Ms. Moriarty.
Good morning. May it please the Court, Marina Moriarty, Special Assistant District Attorney on behalf of the Commonwealth. Your Honors, there was no substantial risk of a miscarriage of justice where the trial judge excused a deliberating juror who became quite ill without a hearing.
He does object, and the judge recognizes his objection. And I think you're making too fine of a point that he didn't specifically ask for a telephone conference, but he does object to the juror being dismissed.
He objects to the judge not holding the jury over for a day. That is his specific objection. And I think the case law is clear that defense counsel needs to make a specific enough objection that the judge can remedy the situation in the moment.
But I think a few pages later, the discussion continues, and the judge says, I understand that you don't agree with this, and I'm going to note your objection to the discharge of this juror. I'm not sure what else counsel was supposed to do.
Counsel should have said, Your Honor, I understand that Your Honor is making certain findings relative to this telephone message that you just heard. But respectfully, Your Honor, the case law requires that we hold a hearing so that we can do exactly what the defendant is now requesting. Judge Krepp didn't have the opportunity to correct himself in the moment. This is a difficult area. Everyone recognizes that. It's particularly, I think you layer on top of this the COVID concerns that were quite relevant at the time this trial was ongoing. Certainly no one was going to disbelieve or second guess a juror who said that they were ill. So I think that defense counsel had an obligation to say, Your Honor, I want a hearing, rather than just the general objection that he objected to the discharge of that juror that day as opposed to the discharge of that juror tomorrow.
Let me tell you what bothers me about this and see what you think. When you're a deliberating juror, you're at the apex of your jury service. So you haven't just been called to court, you haven't been called to the courtroom, you haven't been just put in the box, temporarily, but you're a deliberating juror now. And she calls in sick, leaving a message. So in my view, when you're a deliberating juror, it's different than someone who's working in an office or, let's say, working in a supermarket where you just don't feel well and you call in and leave a message and say, I'm not coming in. Isn't it incumbent on the judge to do something more than just kind of accept that as true, that, oh, okay, she's sick, I'm fine with that?
I agree that the judge should have made an effort to call the juror back and speak to the juror over the phone in the presence of the parties and made specific findings after that particular telephone call. I agree that that's what should have happened pursuant to Connors. But I also would just suggest, and I'm not sure that it's specifically in the transcripts, but the way the jurors are instructed to communicate with the court when the court is closed is to call the number and leave a message if there's an issue. So I don't think that the juror necessarily did anything wrong in this case. I don't think that evinces anything related to the fact that she may have been a holdout juror, that she was having difficulty with her fellow jurors. I think in this particular COVID times when...
Sure, no, I'm not suggesting that. I'm just saying I guess the issue for me is a mere assertion of illness by a juror enough for a judge to discharge that juror? Because that's all we have. We just have a mere assertion, untested, no follow-up.
I don't think the parties suggested that there was any sort of lingering on the part of the juror. I don't think that there was any question that, Judge Krupp specifically said she sounded very out of it. I don't think the parties contested that particular finding with respect to his listening to the voice message. I think it's best practice to have some sort of in-court hearing with the juror over the telephone. But in this case, given these facts, given the COVID times, given the lack of particularized objection, I don't think that there is a specific either substantial risk of miscarriage of justice or even a prejudice that the defendant has articulated. And
wouldn't the purpose of an inquiry, whether it be on telephone or in purpose, would be to ferret out the veracity of her claim?
Sure, but again, she called, let's play it out. They reach her via phone. She's on speakerphone in the courtroom with the parties. Judge says, I hear you're sick. She says, yes, Your Honor, I'm very sick. I'm suffering from a fever, severe GI symptoms. She sounds out of it. Okay. I don't think that Judge Krupp would have done anything differently.
We could have said, is that the only thing that makes you not want to come to jury service? Or how bad, get a little more information about the severity of this. Right. I think that defense has a point that we don't really know whether there's some other reason that was motivating this, or whether this was even a genuine reason. We're just taking basis on a phone message, right? And there's no kind of give and take. Not that we need the judge to cross-examine the juror, but there needs to be some kind of back and forth to kind of figure this out, don't you think?
Yes. In the ideal circumstance. But here, we're speculating based on what would have happened if Judge Krupp had taken these steps that there's no evidence that he wouldn't have had he been alerted to the issue by trial counsel. Yeah. Again, there's also no suggestion that really delaying it a day would have been any more reasonable because, again, even now, at least 24 hours after an illness is a reasonable period of time to be away from.
If they had delayed it for a day, and we'll take judicial notice that serious GI problems, gastrointestinal, are not pretty, that perhaps by the next day, her symptoms would not still be there, and she could participate.
I don't think that's what Judge Krupp would have. If she called in the morning of, say, I forget what day of the week it was, say she called on a Wednesday morning, at least 24 hours would have to go by, and you're supposed to be fever-free for 24 hours, daycare rules, GI symptom-free for at least 24 hours with no medicine. So even 24 hours later, she would be at the cusp of when she would have been able to go back to her jury service. So I don't think that delay, which was really the crux of defense counsel's issue, was unreasonable.
Well, but there's something beyond just the whole the delay issue and the issue with kind of making a credibility determination, because once you get the juror on the phone, then the judge has the opportunity to give the preliminary sort of instruction or warning, I guess, from the Connor case, where the judge should preliminarily inform the juror that he cannot be discharged unless he has a personal problem unrelated to his relationship to his fellow jurors or his views on the case. And that's to overcome, as the court put it, the mere euphemisms for the truth that jurors may come up with. And so that was a great phrase, which did cause me to think, well, yeah, if you're sitting on a jury, not everyone is accustomed to the hurly-burly of, argument and so forth, and it might give someone a stomach ache, and if you're under a lot of pressure, you might not want to go back, and you might start feeling ill. But if a judge gives you that preliminary instruction to sort of assure you that, now listen, if you're sick, that's fine, but if it has anything to do with your relationship with the other jurors, that's not going to fly. You understand that? But we never had that opportunity here because no call was ever made.
It would have been better, but there's no suggestion that this had anything to do with her relationship with the other jurors. The message was that she had a fever, severe GI symptoms, and sounded quite out of it. So there was no suggestion anywhere. So I don't think that the warning to the juror, listen, this can't have anything to do with the jury didn't know if she was going to be discharged for that day. She didn't know if she'd be held over 3 or 4 days. Jurors don't know how these things work. She called in because she was sick, and that's what she reported to the court. And I think that the judge made certain findings about what he heard on that message, and he relayed them to the parties. The parties didn't have a problem with the findings specifically. They didn't ask. I agree they should have asked for a phone call with the juror, but there's no insinuation here. I don't think you can say that a fever and severe GI symptoms where she sounded quite out of it is a euphemism for having some discomfort with, intense deliberations. Respectfully, I think that's speculation. And so again, even if there was no objection, we go to the prejudice. Even if there was an objection, we assess whether there was prejudice under Ronke. The defendant's prejudice is entirely speculative as well. The fact that they came back with a verdict in a quicker time than they had been deliberating previously is of no consequence. So in order for this court to flip this case on this issue, I'd suggest have to speculate that something different would have happened had there been a hearing, and then further speculate that the defendant had suffered some sort of prejudice, which I just don't think on this record.
How can you ever establish prejudice? I mean, we don't know what the jurors were deliberating. You're not allowed to ask about that, right? So it's always going to be some degree of speculation, and that's why I don't know if this is a structural error, but it does seem an error that's kind of reflects the fact that the jury is a little bit of a black box that we can't look into. And so I hear what you're saying about we can't know prejudice, but we can't not know prejudice either.
Sure, and I don't think it's been described as a structural error according to the case law. But again, in other circumstances, it's easier to see the prejudice. If there's some discord previously that's reported to the court, and then a juror reports that they're ill, and the judge makes some questionable findings, and then immediately a person's inserted, and then they come back with a verdict. I think in those cases, it's less speculative that the defendant suffered prejudice than it is here. There's no indication that this was a holdout. There's no indication that they were close to a deadlock. Yes, they had some questions, but that's not unusual for a fairly long and complicated trial. So I would just suggest that this issue was A, not preserved, and B, if this court views it as preserved, that there was no prejudice. If there are no further questions on that particular point, I'd just like to point the court's attention on the authentication issue and the hearsay issue as it relates to the blood vials, to this court's recent decision, Commonwealth versus Berube, 24P 121. It was decided in March of this past year, and that case just goes through a very detailed outline of when and why hearsay on particular items, or writing on particular items is A, not hearsay, and B, how it can be proved, how authentication can be proved on circumstantial grounds. And if the panel has no further questions, I'm happy to rest on my brief.
Seeing none, thank you. Thank you
Your Honor.
both. We'll take it under advisement.
Thank you, Your Honor.
Our next case is 23P1285 in the matter of the Massachusetts Attorney General's grand jury investigation. This matter is impounded, so I'll ask counsel to not use any names. Oh, go ahead, sit down. Mr. Natolo, this case is impounded, as you know, so please do not use any names.
Oh, yes.
Okay, thank you.
That's fine. I'll refer to my client as the
That's fine.
appellant. That's it. May I proceed? Thank you. May it please the court, my name is Michael Natola, and I represent the appellant in this case. Please pardon the butterflies in my stomach. I have been in this court in the SJC, but not for a very, very long time, and as old as I am, I'm afraid you folks still intimidate me.
We'll try our best not to.
Thank you. Speaking of time, that's what the substance of this case is about, time. The government seized or froze the appellant's property in connection, they say, with a criminal investigation 3 years, 5 months, and 28 days ago. They haven't charged him with a crime. They haven't moved to forfeit the money criminally, and they haven't moved to forfeit it in any way civilly. And so the question, so they've been asked, when are you going to return the money? And they've said, if and when a prosecution is commenced, and I quote that on page 32 of my brief. Well, then the question becomes, well, is a formal criminal prosecution going to be commenced? At this point, one would think that it ought to be. I mean, the Warren Commission only took 8 months to produce 26 volumes of findings. I can't understand what the prosecution is trying to prove here.
Why wouldn't they have at least the 6 years until the statute of limitations runs?
Well, they do because of the statute of limitations. However, the cases that I'm familiar with all say that forfeiture has to be brought at a reasonable time, and that the real old cases that I know were all won by the government because of the quote-unquote fecklessness of the claimant. Well, in this case, we have fecklessness on the part of the government. The appellant has never once relented in his efforts to get his property back. They've been asked, when will a prosecution be commenced? And they say, well, when the grand jury is finished with its investigation. That tells us nothing. That's what you call begging the question. It's a non-answer answer. And what we have been looking for all along is a date. I mean, is it going to be 6 months, or as the court says, is it going to be 6 years? Now,
this is a very interesting case, but the problem is the mechanism
yes.
that you chose.
Yes.
I've been doing this a very long time, and I believe your experience at the bar exceeds mine. But I've never heard of anyone intervening, an outsider intervening in a secret grand jury investigation.
Neither have I, Your Honor, and I don't believe there's any case law on it, and I think you folks are in a position to pave some virgin territory here. And of course, the case is about that the government says that we're trying to invade the province of the grand jury, but we're not. We don't care about what's going on in the grand jury. They're going to indict my client, indict him, and then we'll deal with that. We don't want anything disclosed from the grand jury at all. We want the money.
Your motion intervened sought an accounting of the evidence.
Well, I know that, and to the extent that we sought any other relief, right now and right here, I will waive those claims, because as I was preparing this argument, I realized that the only thing that we're looking for is the return of my client's money that was earned legitimately from a...
The Attorney General makes an interesting argument as well, that the grand jury's mission, or their purpose, is to investigate and determine whether there's probable cause and to indict or not indict. It's not within the province of the grand jury under Rule 5, Criminal Rule 5, to return property.
No, I agree with that. It's not up to them. It's up to the government. They're the ones who have it. The grand jury doesn't have the money. The grand jury didn't issue a subpoena for the money. The grand jury didn't issue a search warrant for the money. The government sought a search warrant, and they obtained one from a Superior Court judge.
So why isn't the search warrant presumptively valid?
It's presumptively valid, but there's a mechanism, and I talked about it in my brief somewhere, where, and I offered this, quite frankly, specifically to the motion judge, where there can be a hearing ex parte in camera where the government explains to the motion judge, presents to the motion judge, maybe they present the same affidavit that was presented to the issuing judge, or maybe they present something else. But we don't care about that. I don't care about what they talk about. As a matter of fact, you'll see I described how when I suggested that to the motion judge, I pointed to his, well, actually, to my left, his right, to his lobby. And I said, Your Honor, take them in there. Ask them if they've got anything to justify them holding this money for so long. And so that's fine. That's what the substance of the case is about. But
can I ask about some particular arguments, though?
Yes, sir.
You make a facial and as-applied constitutional challenge to the statute 276, Section 3.
Yes.
But you didn't make those challenges below in your motion to intervene.
Frankly, Your Honor, I must tell you, I just don't recall. It's been so long, and I've done so much on this.
The Attorney General justified the seizure of their money under that statute, but the basis of the judge's decision wasn't relying on the statute. He just said that your client did not have standing.
That's right, and I was just going to get to that, because that's the elephant in the room,
okay,
is standing. And if I can't get over that hurdle, then you don't have very much to decide. However, my conceptual problem is, how can a person with a property interest in property that's been seized not have the ability to contest the seizure of the property? Now, in the recent cases, and especially the De Jesus case, which is a criminal case, and I understand that, the concept of standing has been abolished, and all that a defendant in a criminal case needs to do is show that they have a privacy interest in the property.
Well, your client certainly has a property interest, yes, in the money. The Attorney General is not going to question that. But I guess the issue is not if he'll have an opportunity to get the money back. The question is really, when will he have an opportunity?
Yes, and I suppose I suppose he will have an opportunity to do that. He's 76 years old if he ever sees the day. It's the when part, and you're right. This has become, I most respectfully suggest, a constructive forfeiture. They've got the money, they won't give it back, and it's been forever since they've had it. In another context, if we had challenged it on these grounds, we would have had, the question of standing would never have been raised, And quite frankly, I think on the merits, we would have won that case. But again,
I'm sorry to
Yes.
interrupt. You did bring a civil action.
Yes.
And sought a preliminary injunction.
Yes.
That Judge Buckley, I believe, of the Superior Court denied it.
That's right.
But you didn't pursue that to appeal.
No, Your Honor, because I did the research on it, and I decided, as is my duty as I see it, as an officer of the court, not to pursue a frivolous appeal. I thought she was exactly right. Now, that's the other problem. You can't get, from their point of view, you can't get relief in a civil case. You can't get relief in a criminal case unless it's brought at some unknown time in the future, and you can't invade the province of the grand jury. This is where we are, and as I said, I don't want to repeat myself, but we have no interest in the inner workings of the grand jury, and the seizure of this money, quite frankly, Your Honor, has nothing to do with the inner workings of the grand jury. It has to do, as I said before, with them applying for and receiving a warrant to freeze that money and them not giving it back. I mean, that has constitutional implications.
Sure, but they can't obviously do it forever, right? There has to be some forfeiture proceeding if they
Yes,
want
sir.
to keep it full-time. And so when that forfeiture proceeding, if there is a forfeiture proceeding, then there will be a due process that you'll be able to contest the forfeiture, right? And so we're just talking about this kind of interim period with the grand jury investigation. Obviously, it's frustrating to your client that it's taking so long. I would think you'd have a stronger argument if there was no conceivable criminal charge that could be brought based on the statute of limitations having run, but we're not at that point yet, right? So it seems like everything you're making these arguments that sound due process, but the fact is there is going to be some due process before your client loses whatever property interest he has. Would you agree with that?
Some due process, meaning the issuance of the warrant?
No, ultimately with a forfeiture. If the Commonwealth is going to intend to retain this money in the long term,
Well,
there will be a due process with that, correct?
well, with that, at some unknown time, again,
Right,
that's
right,
the
right.
question.
But presumably
And
within the statute of limitations period.
now, the Assistant Attorney General, at the time of one of the hearings, and it's on page, excuse me, 107 of my appendix, says plainly, but it would be forfeited at the end. So that's what they intend to do. They intend to forfeit it. And again, a forfeiture must be brought within a reasonable period of time. This is not a reasonable period of time, no matter what. And again, that's the substantive argument. But if my client does not have standing, which is what's really been the big issue here, then he's got to wait till an unknown time while the government has his money that he earned legitimately, that he intended to put into business ventures, and he can't use that. As I say, it's really it's a constructive taking, and they don't want to give it back. And them, the Assistant Attorney General on that day, quite frankly, proves it by saying the money would be forfeited at the end. So it's.
Can I ask you another procedural question? The Attorney General says your appeal is interlocutory, so it's
Yes.
not properly before us, they say.
Yes.
Why do you say it is properly before us?
Because, Your Honor, I'm sorry I don't have this at the tips of my fingers. There is no case like this, so there's nothing that I can analogize it to.
Well, you do
But
analogize.
I have an answer for you.
Oh, go ahead.
Yes, and the answer is that is in the Mass Federation of Teachers case that I cite in my brief. I believe they say that, and I don't want to misquote them, but I believe what the court said in that case was that under certain circumstances, an interlocutory appeal is proper, can be proper, an appeal can be brought on an interlocutory basis from the denial of a motion. And that's really the case I rely upon.
And that's in a civil context.
Yes, it is.
Yeah.
And as I say, this is somewhere in the ether. It's neither fish nor fowl. And that's why you have the opportunity to make new law. Thank you.
Thank you. Ms. Nixon. Why don't we start there?
Sure. And just to introduce myself for the record, good morning, may it please the court. Nicole Nixon, Assistant Attorney General, appearing on behalf of the Commonwealth. And I'd be happy to start there, Your Honor. Just as an initial matter, I'd point out that the appellant below did not raise an argument or analogize his circumstances to Rule 24A of the Rules of Civil Procedure until the motion for reconsideration stage. At that point, the argument's raised, or excuse me, the argument is waived. The argument was not before the Superior Court judge at the motion to intervene stage, at the motion to intervene hearing. It came in after the fact, after the motion to intervene was already denied. So on that basis alone, I don't think that argument holds a lot of water because it's waived at this point on appeal. But even assuming this court looks past the waiver issue, Rule 24A is a rule of civil procedure. We're in a grand jury proceeding.
I follow that it's not, obviously this is not a civil case, it's not a civil investigation. But where in the civil context, they say not only the rule permits it, but logic, it only follows logically that if you're denied the opportunity to intervene in the case, your participation is at an end.
Sure.
How is that different here? He's told you can't get involved and you just have to sit and wait.
I recognize that, Your Honor. However, in the intervention cases in the civil context, I think it's a little bit different than in the grand jury context. One, because in the civil context, a civil litigant who's attempting to intervene in a case, that's their only opportunity to be involved in that case. Their interest in that case to intervene, they're attempting to assert an interest in that case that they say can't be protected.
This gentleman certainly has an interest in this enormous amount of money.
Sure, but that's not the subject of the grand jury investigation. I think that's the point. The subject of the grand jury investigation, we don't know, nor should we know. It's a historically secret process. There's some connection between the property that was lawfully seized pursuant to a search warrant and the investigation. However, the purpose and the subject of a grand jury investigation is to see whether there's probable cause to indict somebody. That's the ultimate end. The motion for return of property, which is what he's substantively attempting to intervene into the grand jury investigation to litigate, the grand jury can't decide that, nor can the supervising judge of the grand jury decide that. So intervention isn't even appropriate here, even if we were to analogize this case to a civil case and use that Rule 24A.
So if he's not indicted, he just has to wait till the statute runs?
That's not necessarily true, Your Honor. There is a duty on behalf of the Commonwealth and on behalf of the state pursuant to General Laws Chapter 276(3). Once it's determined that the property that was lawfully seized pursuant to a search warrant at the time is no longer needed for evidence in an investigation or trial, to promptly return that to their owner. We're just not at that stage right now.
Is that happening anytime soon?
I'm sorry, could you repeat that?
Is that happening anytime soon?
Your Honor, the record, there's no development of that issue on the record, and that's for good reason. The Superior Court judge specifically denied any attempts by the appellant to get any information regarding the investigation, regarding the status of the investigation, and that's for good reason, because the intervention issue, that information has no bearing on the intervention issue into a grand jury proceeding, and whether he has standing, meaning the ability to intervene in this forum to litigate that issue.
How long can this go on for?
Your Honor, that's a tricky question because it's really fact-dependent. Investigations are very different in many different contexts. Some can take a short amount of time, some can take a long amount of time, and I recognize that's not a very satisfactory answer.
It's not, yeah.
However, that's That's the
Go beyond
fact of
the-
a criminal
can you go-
investigation.
Can it go beyond the statute of limitations for any underlying offense that may be at issue?
No, I think it is cabin in some respect to the statute of limitations, which for most crimes is 6 years.
Right. So up to 6 years, then the Commonwealth gets to kind of freeze this money. It doesn't have to go and actually make a case for forfeiture. It's just in limbo, and there's really nothing that a purported property owner can do to challenge that during that period. It seems like a little bit of a problematic situation.
I would disagree with Your Honor. There's nothing that a property owner can do. I recognize here that the appellant did file a civil action and that was dismissed. However, if you look at the actual dismissal, if you look at the Commonwealth's motion to dismiss, which was unopposed, one of the main reasons for that dismissal is because of the mechanism that he attempted to sue civilly. He attempted to sue directly under the federal and state constitution. However, there's no right of action directly under the state or federal constitution. In my research and preparing for this case, if you look in the federal sphere, some people in this type of situation have filed procedural due process claims similar to the one that the appellant's attempting to make here in the context of a 1983 claim. Now, I'm not suggesting that that would be appropriate here. I'm not suggesting that there would be a basis here, but I think that is an avenue that potentially could be explored for somebody in an appropriate situation.
A 1983 claim, though, would that be interfering with a state court proceeding, though, right? You'd run into kind of younger issues, right? At least if you did it in federal court, right?
Heck versus Humphrey.
Versus Humphrey.
Sure, that's right. However, again, we're kind of speculating right now, right?
We're just trying to find out if there's any avenue for relief, or people
Sure.
just lose access to their money for 6 years, and then maybe there's a forfeiture proceeding, right? I mean, maybe that's the rule. I don't want to.
Yeah, and yes, and I acknowledge the younger doctrine of cases. I acknowledge Humphrey, and I acknowledge that that may be a defense in a particular circumstance where there is a continuing ongoing investigation, a continuing state proceeding. However, in that situation, once somebody has been indicted, once a criminal proceeding is initiated, then there is a mechanism in Massachusetts to seek that return of property if it's determined that it had been unlawfully seized via a motion for return of property filed pursuant to Massachusetts Superior Court Rule 61. As Your Honor pointed out, once forfeiture proceedings have been initiated, somebody obviously has their due process rights there with a notice and opportunity to be heard before that property has been permanently deprived.
Was there a constitutional challenge below to 276.3?
No, Your Honor. Our position is that it was waived. If you look at appellant's motion to intervene, their supplemental memorandum, I believe there's maybe a sentence just baldly stating that General Law, Chapter 276, Section 3 is unconstitutional. However, that's not a developed enough argument hidden within a multi-page motion to thoughtfully bring out the argument for purposes of it being fully developed. So in that circumstance, we would argue that is waived, and none of the constitutional arguments should be considered here.
Just a kind of a practical question. In the event that government decides to give this individual his money back, and let's say a number of years have gone by, does he automatically get interest on that?
Your Honor,
in other words, is he made whole at some point?
Your Honor, I don't have the information to answer that question. That's not, in the record. Well, that's not within the appeals court record here. I understand it's a practical question.
Is it in an interest-bearing account?
The assets were, so the way the search warrant worked was the assets were frozen in that bank account. I'm not particularly sure about the mechanics of that particular bank account or when an account is frozen if there's interest bearing. But this wasn't a situation where the government physically seized the money and put it into a different account. The money is frozen in the bank accounts at this point in time, pursuant to a lawfully issued search warrant.
And just one other question. Would you agree with your brother's statement that he made that an assistant attorney general had informed him that the government does intend to forfeit this property?
That is in the record. It was at a sidebar. I believe it's on. I believe he correctly cited the record at Record Appendix 107. There was just some discussion about forfeiture, and an assistant attorney general at the time did make that statement. Clearly, the Commonwealth has the discretion and the ability to forfeit property that's deemed to be contraband or evidence of criminal activity.
It has to be forfeited within a reasonable amount of time. what's reasonable from the Attorney General's perspective?
Your Honor, again, I think it's a sliding scale. It depends on the status of an investigation at a particular point in time. It depends on the Commonwealth has the ability to build a case for forfeiture as well, and to build a strong case for forfeiture. I understand that once probable cause, that there's a lower standard, a lower probable cause standard, and once that probable cause standard is met, forfeiture proceedings can be instituted. However, they're not required to be instituted at that time. Certainly in the forfeiture context, a property owner would have the ability to file a motion to dismiss that forfeiture proceeding based on a delay. That could potentially be a mechanism that could be affected in an appropriate circumstance. And if there's no further questions, I would rest on my brief as to the remaining arguments.
None. No, thank you. Thank you both. Very interesting case. We'll take it under advisement.
Thank you.
The next case is 24P696, Department and Children and Families versus Father. Remind the attorneys that this case too is impounded, so please do not use names, use descriptive titles or some other adequate substitute for names. Ms. Dow.
Good morning. May it please the court, Attorney Deborah Dow for the father who is listening on the YouTube live stream this morning. Both DCF and the child cite to adoption a veto for the proposition that the judge is not required to consider race in termination of parental rights cases and in placing children for adoption. But veto cannot be read in individual sentences or piecemeal. It really does need to be taken into context, in complete context, which DCF and child fail to do here. The question in veto isn't whether the foster parent can so assimilate these children into her world that they lose their racial and cultural identity as well as their heritage, but whether the children's identity and continued connection to their race, culture, and heritage is in their best interests. Termination of parental rights cases are not adoption parent-centric. They are child-centric.
But there is a regulation that prohibits discrimination based on race. So, for example, 110 CMR 1093, the department shall not deny to any person the opportunity to become an adoptive foster parent on the basis of race. So it's actually prohibited.
And in the same section, or the section above that, Your Honor, is DCF regulation that says that they can also recruit regardless of race. So on one hand, they're saying one thing, on another, they're saying something different. I would also point—
Well, recruiting is like recruiting like a pool of foster parents, right?
They do not, correct, that they do not have to align necessarily, away from race either.
So they're not inconsistent. You can recruit a pool, but also not discriminate when you're seeking to place a child with a particular foster parent.
Correct. Okay. But I would also, again, and I would point the court to the ICWA regulations, not just the federal regulations, but the mass regulations as well, which set out the fact that— But they don't apply here, though, right? Well, there's no Indian connection, right? So no tribal connection, but actually the Commonwealth does make a distinction in the regulations and says that even though there's no direct tribal connection, the court and DCF are still required to look at that as part of the analysis, and that's in the regulation. In addition to that, the cultural sensitivity, sort of dovetailing off of that, is echoed in 88001 as well as 110107, which says that if there is a Native American, doesn't matter if they're tribal affiliated, and they're placed with a non-Native American, that there has to be some sense of whether or not that person is prepared as far as cultural identity, heritage, and an understanding of what that actually means.
Yeah, but these regulations all refer back to ICWA, so I mean, if you don't qualify under ICWA, then...
Well, again, the distinction is made that even if ICWA doesn't apply here in the Commonwealth, even if the federal statute, it's in and of itself doesn't apply, that the tribal affiliation is, with a tribal affiliation, that there still is application here in Massachusetts. Excuse me. The judge, at a minimum, had this information, although it was somewhat scattered, but in a cumulative sense, that information was there as far as the racial makeup of these children. He had it before him not just once during the actual proceedings, but in addition through the 60B motion. The father's family, mother, and even mother's family were all accessible to the court. There was no conclusion or determination as to best interests of these children based on those factors. The absent placing the learning of that, the learning of the culture and race and heritage on what was then a 6- and a 7-year-old siblings that were placed in a separate foster home. The judge, at a minimum, knew that the children did not look enough like the foster parent, the pre-adoptive parent, to assimilate, as was the case in Vito or as was set out in Vito. Mother was present for the colloquy, father was present for the trial, and the pre-adoptive resource was present the entire first day of the trial in the courtroom. This wasn't just a failure by father's counsel, but by child's counsel, the department, as well as the judge. DCF did not follow its regulations. And these policies and regulations, as I said, came into effect post-Vito. So these regulations have developed over the course of time, and assuming through some awareness as to the protections of racial minority children being placed in homes outside of their race, culture, and heritage.
Are you saying that the judge should not have placed this child with a person of a different race? Or these children with a person of a different race?
I'm not advocating or suggesting racial matching. And I think Your Honor referenced the regulation that says that there is no discrimination or there should not be discrimination in placements through adoptive resources. However, that said, certainly that information was before the judge, and it's important information. It's important information to these children. And it seems as if it's just as important as the information on socioeconomic welfare of these children. It was espoused several times that these children play soccer, they go to Lake Winnipesaukee, they are learning to ski, and yet we have no background or information on these children as far as their race, culture, and heritage.
Well, what would you have had the judge do differently?
The issues here with the race are certainly all intertwined with the ineffective assistance of counsel claim, including the fact that the regulations were not brought forward, followed by DCF, and then there was no accountability from the perspective of father's counsel with respect to enforcing those regulations. And I would also suggest that the judge has an obligation, having some understanding that these children were minorities. They're Black, Hispanic, Native American, and a very small part Caucasian. That information was available. and yet nothing was done with that
Okay,
information.
but what is, this is what I'm trying to get to. You keep repeating that, the nothing was done, but what is the thing? What would you have had the judge do differently than what he did? Because he did consider it. He considered it especially in the post-trial motion, in the motion hearing, and he addressed it. But what would you have had him do differently?
So I think he addressed it, dismissed it as a factor. But what I would have him do differently was what the regulations require DCF to do and the judge to look at. What services were offered to this white family to assimilate? What community services? What development of their understanding of what it means to be involved in systemic bias? What it means to be of a racial minority in a white household? That's all required in the regulations, and DCF didn't do it.
DCF didn't make fun. I'm sure my colleagues, I understand the issue that you're raising in general terms, but I'm trying to get in concrete terms, what exactly should the judge have done? Made more findings along this way? Made more of an inquiry into these issues? Just focusing on what the judge's role here for a sec.
He should have considered it as part of the adoption plan. Was it in the children's best interests? Those determinations are part and parcel of a best interest determination and the standards of best interest. We're not just looking at these children in a particular vacuum. As I said, it's not adoption parent-centric. So yes, he absolutely should have looked at all of those factors that are in the DCF regulations. And was this placement in the best interests? There are two additional claims here. One, ineffective assistance of counsel. And that, I would suggest to the court that what father's trial counsel did or did not do throughout the case started with day one of this case and impacts a variety of arguments, including the reasonable efforts argument. So there were no motions filed, no motions for lack of reasonable efforts, no motions for abuse of discretion. They were aware that she was aware father would be coming out of prison. No motion for a continuance. No motion to enforce DCF to do what they're required to do, again under the regulations, assess him, go to the jail, hold meetings at the jail. In their foster care reviews, an independent panel determined that father was not aware what was on the service plan. That was in 2022. And so they couldn't evaluate him or assess him at that time. And subsequently, in 2023, that DCF still was not meeting the needs of the family because of their inability or refusal to work with the father. None of these issues were brought forward. It's not just, this isn't just about motions in limine and failing to file those. This is a complete case where there was ineffective assistance. And the third issue.
But, you know, I mean, in defense of counsel a little bit here, I mean, she was kind of faced with a difficult situation where you have an individual who has had virtually no contact with the children because of his incarceration that stemmed from a domestic incident in front of these very children. So that would seem to be kind of the focus of the case, and you seem so. What of those motions would have sort of had bearing on kind of the main issue in the case?
Well, the issue, obviously, of paternity and establishing that early on or earlier on than it was. From the time that mother acknowledged paternity and DCF let it be known that this was an issue, it took counsel an additional, I believe, 8 months to have paternity established. And in that time, DCF was not allowing the father to have visits, and therefore there was no parent-child bond that was forming or that could possibly form because of the lack of visits. In addition to that, there was a motion for visitation that counsel filed very early on in the proceedings that was never brought forward. there was a proposal for, I believe, 10 or so supervisors, of which 7 were state employees, presumably carried, presumably available, and yet that motion was never brought forward, so Father early on took it on his own to pursue visitation. So in addition to that, those are bonds that could have formed and formed appropriately. Subsequent to the paternity, Father wasn't getting consistent visits. I think that was testified to. And in addition to that, there was, it seemed as if Father did do well during the visits. There was nothing to suggest that he wasn't appropriate or engaging. And that was part of the action plan, that he was able to do that, and he was successful in doing that. I would just quickly turn to the third argument in the case, which is that Commonwealth versus Mattis applies here in this case.
Has it been applied in any other DCF case?
Not that I'm aware of, Your Honor. I believe, because it's such a new case, that this was part of my motion for a new trial subsequent to that. But I would suggest that it's applicable to this case to my client who was 20 years old at the time that the children were born and removed from his care. And the judge made findings throughout that were essentially replete, multiple conclusions, multiple findings that Father was going to be unfit into the future based on his juvenile and adult record when he was considered to be.
Well, his criminal behavior continued after he emerged as an adult.
I'm sorry, Your Honor?
His criminal behavior continued after he emerged as an adult, 21.
He was 20 years old and
But he was 21 when he assaulted Mother, right?
he was 20.
He threatened Mother and the children with a firearm
Correct. Yes,
when
I
he was
believe
21.
20. So, and that piece was, the suggestion is that the judge cannot just look at that and use it for prognostic value.
Oh, all right, thank you. Your time is up.
Thank you.
Mr. Bayless.
May it please the Court, Jeremy Bayless for the Department of Children and Families. This is a case involving a young, violent father who was unwilling to work with the department and at times actively impeded the department's efforts to work with him. But before digging too much into the specifics, I think it's important to start with the ineffective assistance of counsel argument because that sort of provides a framework for the whole case. Many arguments were waived, and it was not ineffective assistance for counsel not to waive them, but should be addressed nonetheless. In order to prove ineffective assistance, they must show that the conduct of the counsel fell below that of an ordinary fallible attorney and that Father was prejudiced, that they were denied some otherwise available grounds for defense, and Father can reach neither of those prongs. The purpose of ineffective assistance is not to provide a hindsight-based recitation of motions that could have been followed. Rather, it's to identify something that could have happened that would have helped the father, and that is not done here. The motions for visitation, there was a motion for visitation filed that wasn't acted on quickly, but that was rendered moot when Father threatened to kill either Mother or the children, was incarcerated, and had a year-long restraining order prohibiting contact with the children. There certainly was not below the performance of an ordinary fallible attorney to not move for visitation that was prohibited by a restraining order. Father refused to sign the birth certificate when it was presented to him, and there's no indication that the delay in his pursuing parentage was due to any inaction by the attorney other than just the bald statement that it didn't happen and must have been ineffective assistance. Furthermore, and then visitation was resumed when Father did finally get that adjudicated. With regards to the motion practice at trial, this was addressed in the 60B decision. While the court chided Father's counsel for not filing a written motion in limine, the court did apply the Luke doctrine, and evidence was not admitted wholesale It was admitted restricted as the law applies. Furthermore, there's nothing identified in the motion that was admitted, should not have been, and was not duplicative and relevant. There's no indication that father was denied an otherwise available defense.
What about the issue about the children's racial and cultural needs? Because you do rely on the fact that the father didn't present evidence at trial or an offer of proof on those issues, and you kind of sort of use that to kind of justify how those issues were dealt with.
Sure. And
So it does seem like you're, you can't say, I mean, maybe you should get to the merits of that. I mean,
well, that's why I want to talk about ineffective assistance first, because what is sort of the kicker there is that there is no evidence that these children had individualized needs that needed to be addressed through an order somehow involving pre-adoptive parents of a different race. And that needed to have come in the ineffective assistance motion, some offer of proof as to what should have been raised and wasn't. It is not the case that just when we have a cross-race or cross-cultural pre-adoptive home that is in and of itself.
So you don't think there's any independent need for that to be considered, regardless of whether a party is raising the issue?
It is certainly not
under your
air
regulations
when it's not raised for the court not to sua sponte say these kids don't look like that pre-adoptive placement and therefore I need to take extra steps. There are children for whom it is a crucial issue and there need to be specific things taken to preserve it, and there are children for whom it is a less essential issue where, as Vito acknowledged, the presumption that adoptive parents are going to act in the children's best interest. That doesn't just mean that the pre-adoptive parents are going to somehow merge them into their own culture. Rather, it is that if it becomes a point of contention, the assumption is the pre-adoptive parents will take efforts to try and address it, to preserve their cultural heritage, to work with them to deal with bullying that happens later in life. The many different things that can come from these cultural issues, but none of it is required, is it air for the court not to affirmatively dig in, particularly in cases such as this where there is no other plan. This is not a competing plan case. Father didn't put forward any other family members, and other than identifying that these people existed, there's no indication in the record, in the motion for new trial or anywhere, that they were willing to come forward. They were willing to be a placement option. They weren't. It was reunification with father or the department's plan of permanency by adoption with these caretakers. It certainly is always better to have more information before the judge, but it was not air for this not to be, for the judge not to have done more. And I think what's partially telling is that my sister can't identify what the judge actually should have done. They're working with the evidence presented. The evidence presented was that...
Well, I think she says there need to be more of an inquiry, there need to be more findings made, there need to be more of just engagement with this issue.
Certainly. And the problem is that it's not tremendously hard, but it is a path to navigate between the prohibitions on racial discrimination and obviously the obligations to ensure that the children are supported and that their cultural ties are maintained intact. And it becomes concerning when the judge is doing that sua sponte. Not to say that there aren't plenty of situations in which that can happen, but to prove error, there needs to be more than just the children are a different race than the pre-adoptive parent, and that was silent. There needs to be some indication that then subsequently would have impacted whether placement was in their best interest, and that wasn't raised at trial. And there's nothing put forward in the motion for new trial or in the arguments of ineffective assistance that would indicate that these children had a strong connection with their Native American heritage, with their specific Black heritage, with their specific Hispanic heritage, that needed to be considered with the judge beyond just the statement that they are of different races. And so that does not provide grounds for disturbing the decision below and disrupting these children's attempt at permanency. Then I guess I'll move to the argument of Mattis. Justice Meade, you are correct to ask that this has not been applied in child welfare cases. And the reason for that is not only because it is a criminal case involving, the constitutionality of life imprisonment, which applies a variety of different legal standards that aren't present here, but it's also because the case law has been consistent that the focus on child welfare proceedings is on the best interest of the children. Certainly parents have rights that need to be preserved, but they take a back seat to the best interest of the children. And we see this in cases where parents, because of unrelated to age, mental health issues, developmental issues, are through no fault of their own, unable to provide the parents with care. It is not the case that children have to wait potentially years during the limited childhood they have, during crucial developmental situations where they, periods where they would be developing as people, for their parents to reach a point that may never happen, that there is not more than a faint hope of occurring where they could be able to parent them. This is a parent who was extremely violent. He beat the 9-month pregnant mother until she was vaginally bleeding. Then the children were born. He did engage, he completed a batterer's program, he engaged in intimate partner violence program, and then 3 weeks into that intimate partner violence program, assaulted mother and threatened to kill either her or the children, leading to his incarceration. While he was incarcerated, he denied having a prison social worker when the department's worker attempted to talk to him about how to coordinate with him to work with him in the prison. He was not providing the evidence of completion of the programs, the services that he claimed that he had engaged in. The court found that the children, it was in their best interest not to have to wait indefinitely for the hope of his improvement, and that was not error. And Mattis does not provide a grounds to lengthening the time.
Well, so Mattis is obviously distinguishable. That it's dealing with criminal punishment and what's fair under those circumstances. But it is talking about adolescent brain development, post-adolescent brain development. I think the point that might be drawn from that that's relevant to DCF is that you can't necessarily make firm predictions of behavior that occurs during the post-adolescent period in a way that you might in subsequent years. Not to say, so there might be insights from Mattis that seem relevant to what the department does and what the courts do in these cases. I'm not saying there was any error here, but it's not like it's a completely relevant area of inquiry, right?
My time just stopped, so I can briefly respond.
Yes.
I think the situation in which the brain development might be more relevant is in discussions of the services that are provided and discussions of how the cases are proceeded and a parent is treated. Because it certainly cannot be the case. The judges have to make that decision. When the case goes to trial, the judge has to make a prediction as to what's going to happen. And it can't be the case that children are unable to be freed for adoption if their parents aren't a sufficient amount of years past the age of 21. And that I guess is where I will leave it, and that is where the judge was had to leave.
Thank you.
Thank you, Your Honor.
Mr. Katz.
Good morning, Your Honors. Daniel Katz for the children. I think we all agree here that the overriding concern in these cases is what is in the best interest of the children. And children, not just these children, but all children in this Commonwealth, have an absolute right to be free from abuse and neglect. And two images that I would like Your Honors to visualize. Here we had a man who elbowed the pregnant wife in the stomach while these twins were in the womb. Despite taking services, and as we know from the SJC and in this court, participation in services is not enough. And here we have a textbook example of someone who did attend some batterer service and then battered again. Not only battered, but threatened the life of the mother.
Mr. Katz, please don't touch the microphone.
With a firearm in front of the children. I think this case is open and shut, given the violent history which the father admitted to on the stand. Yes, I have a violent history. The judge properly concluded that this person was unable, given a batterer's program, to deal with whatever problems he had that made him become and continue to be a batterer. And the judge was able to rely on those incidents, one which did not involve incarceration, well, only briefly, and then the second one which did involve incarceration. So all this talk is trying away from what happened to these children while in the womb and subsequent should make your honors simply decide that this parent was given the opportunity to proceed with services and he was unable to learn anything from them. And the violence should be realized that it is unacceptable to put children in any harm. Parents have rights, but it is not absolute. The children have an absolute right to be free from abuse and neglect. And the only way that that could have been achieved in this case is what the judge properly did in terminating father's parental rights. He has never cared for these children. They have been in this foster placement with this foster mother since they were about 3 months old, where they currently reside today. There was a termination visit. The visits when he was incarcerated over the Zoom, he behaved appropriately, but that certainly should not be considered sufficient for a man with such a violent history who has never cared for these children. If your honors do not have any other questions, I'm happy to stand on the brief.
Thank you. Thank you all. We'll take it under advisement. Do you want to do another one? Sure. Want to do one more? Yeah. The next case is 23P184, RENZULLI versus Sullivan. Mr. Haytanian.
May it please the court. My name is Harry Haytanian. I represent the appellant, Sean Sullivan. The issue before the court is pretty straightforward. Did the trial court abuse its discretion and commit an error of law when it used the term weather-tight in ordering what essentially was a rebuild of a burnt-out condominium? The facts of the case are undisputed. On July 9th, 2022, Five-Step Lane was decimated by a fire that started at an adjacent property, the Veranda House. The fire spread to Five-Step Lane. It also spread across the street to Four-Step Lane. Three-Step Lane, which is the Veranda House, and Four-Step Lane, which was a neighbor's property across the street, were also destroyed. Three-Step Lane, the Veranda House, demolished. Four-Step Lane was boarded up and fenced off. Five-Step Lane was essentially rebuilt. The question becomes why? Why was it rebuilt? And the answer is this, that the trial judge, relying upon representations about what was required, abused its discretion and committed an error of law when it inserted the term weather-tight in an injunction, allowing essentially the plaintiff to utilize that term to rebuild the common areas. Now, the record is clear. The entire structure was essentially destroyed. The plaintiff's complaint admits as much. claims adjuster, Battolino, submitted the entire policy for the common areas. The plaintiff, Ms. Renzulli, filed 2 lawsuits in late October of 2022. The first was filed in the land court seeking declaratory judgment pursuant to 183A, Section 17, that the parties had, that she alleged, reached an agreement to rebuild. She also filed a cause of action in the Superior Court on the same day, alleging that my client has breached a fiduciary duty, and she sought injunctive relief. 183A, Section 17 provides that in the event that 10% of a common area of a condominium is destroyed by fire, and 75% of the unit owners are unable to reach an agreement to rebuild within 120 days of the fire, any of the unit owners can petition either the probate court or the land court to have the property sold, all of it sold.
Right, you're kind of jumping to the merits here, but is the repair that was done as a result of the preliminary injunction, is that over?
Precisely, Your Honor.
The weather-tight repair is done. So even assuming that you have standing now to appeal from the preliminary injunction, which I'm not sure you do, what relief do you want us to provide given that the repair that was contemplated by the preliminary injunction is already completed? What can we do? What can we possibly do?
You can render the injunction invalid because we sought to modify it and to have it.
What good would that do? Because the relief has already been provided. Is it a moot?
Well, it's actually quite practical. The relief was because the plaintiff is seeking to utilize the injunction both to hide from her own liability for participating in what was essentially a process of misleading the court as to what was required, and her contractor is seeking to use the injunction in order to get paid. My position is that the injunction never should have been granted. The facts of the case is...
Okay, but what say we were to agree with you and say, no, that was a bad preliminary injunction, reverse the preliminary injunction,
Right.
What happens then? How does that possibly benefit your client, given that the repair work is already finished? The weather-tight repair work is done. What happens?
Well, my client has also asserted abuse of process claims.
Yeah, but those are merits claims that you're going to go back and presumably go ahead with this litigation, and you can litigate all those issues if you want. But what's
Right.
before us now, I just don't understand what you want us to do that's going to make a difference.
Declare the injunction invalid. It was an abuse of discretion. I mean, I think
Well,
you're...
why? You have to have...
Right, well, let me address that.
Why is this a live issue?
Okay, let me address that specifically, okay? With respect to what is required for maintaining the status quo after a fire. Chapter 143 specifies in those instances, the building commissioner informs the parties that because the property is uninhabitable and it's a danger, it needs to be cordoned off and either demolished or it has to be boarded up and fenced off. Now, that is the law, and that needs to be clear to the other justices of the Superior Court. In that context, Your Honor, if the trial judges are allowed to go ahead and simply create standards that don't exist in the law. I mean, the law is clear, Your Honor, under 143 and 780 CMR 116, that in the event of a fire, the court...
But what practical difference? That's what I'm trying... I know you want us to tell the Superior Court judge that they got it wrong, but what if the work to make the property weather-tight is finished? We're not going to... You're not hoping to undo that work, right? The litigation is going on in the Superior Court, so I'm not sure what you're hoping to gain from a decision here.
The injunction itself was invalid to begin with, and there are substantial counterclaims against the contractor and claims against Ms. Renzulli that relate to their participation in what was essentially misleading the Superior Court. There's a deeper dive here, Your Honor, and I think without opening the entire story up, if you will, Your Honor, what I think we need to stick with here is, was the injunction valid? And it was, clearly wasn't. It wasn't valid. Whether
Say hypothetically we say, oh, the preliminary injunction was invalid. How does that make any difference to your case? You still have to go back and litigate the case in the trial court.
Well, yeah, there are.
What difference does it make?
Well, in common law, there is a cause of action for a wrongful injunction. This was a wrongful injunction. In order to prove that, Your Honor, we have to start with, well, what did the court do? And what the court did was abuse its discretion, and it committed an error of law. What the court should have done.
Then we get back to the fundamental question of you didn't appeal from the preliminary injunction order.
We appealed from the trial court's denial of our request to modify and clarify. And
it's quite clear under all the case law that a motion to clarify or to reconsider does not provide a separate event that's appealable.
Okay.
Right? And so you have to show there was some kind of changed circumstances
Right.
that justify an effort to modify the preliminary injunction, which you did
Correct,
not
Your Honor.
directly appeal
Right.
from. And your changed circumstances are you got more affidavits from experts, and you brought those in. But those really aren't changed circumstances. You're just sort of, that was like your second bite of the apple challenging the preliminary injunction order, right? So what actually changed since the entry of the order that would justify making this a new live issue that's an appealable event?
the utilization of the term weather-tight to rebuild. Weather-tight, and this is clear from Mr. Cabral's affidavit, okay? Weather-tight has no definition under the code, and it doesn't exist. So the judge used the term, and which could be interpreted, and you see Mr. Cabral, who is a licensed construction supervisor, says this term could be interpreted to mean anything. It could be interpreted to mean put a tarp up. It could be interpreted to mean anything. The way they interpreted it was to rebuild the common area. That had to be clarified. That was new information. This is what they're doing, Judge. Not only are they doing it, Your Honor, they're doing it on a structure that Mr. Galligan, who's a licensed structural engineer, looked at and said, this could collapse. An additional fact, Your Honor, that we didn't have is the plaintiff was bringing people into the structure, and she was parading them around on joists and structures that Mr. Galligan claimed could collapse at any time.
What difference does that make to
Well,
anything?
it
I don't
exposes-
understand. Like we don't review clarification orders in interlocutory appeals, right? We review maybe preliminary injunctions under narrow circumstances, but that's not what's at issue. It's the subsequent clarification of the word weather-tight. You think that's an issue that the appeals court should rule on?
Most definitely. I think under Section 2 of 231, most definitely. You have jurisdiction, Your Honor, over that injunction to make sure that that injunction is valid.
We did if you filed a notice of appeal from the injunction.
We filed a notice of appeal on the modification and the clarification.
Which is untimely.
No, Your Honor, it's
vis-a-vis
not.
It doesn't toll the time for filing a notice of appeal on the PI.
No, but under the statute, Your Honor, the language states quite clearly that it includes modification and clarification of the injunction, and that's precisely what we sought. The injunction was issued and it used a certain term. And the term then we found out was being utilized in a certain way, and we went back to the court and said, Your Honor, please define this term and limit it so that it is not being utilized to rebuild. And that's perfectly appropriate under 231 Section 2. This court has jurisdiction over that issue. And when the court heard the evidence that this is what was going on, it then came up with even a more broad definition of weather-tight. It went to Webster's dictionary of all places. It didn't go to a statute. It didn't go to a regulation. It went even further down this road of...
Not uncommon to use dictionaries to define terms.
I understand, Your Honor, but what it had before it was 780 CMR 116 and 143 that utilize very specific terms about securing structures, fencing them off, boarding them up, or demolishing them.
Okay, so what you seem to be saying is that the reason you didn't appeal the preliminary injunction is because you were satisfied with it. It wasn't until the judge went back and took another look at it and then materially changed what the injunction was, that then you said, hey, this isn't right, and that's why you appealed at that point.
Partially, Your Honor.
Okay, what's the other part?
The partial, Your Honor, is when you use that term weather-tight, it could, like I said, we understood it to mean basically, put a tarp over it or something like that. When we saw the way it was being utilized, we went back to the court and said, Your Honor, we need to tighten this up, okay? We need to tighten, and you have authority to tighten this up under 230, you have authority to review what the judge did at that point under 231, Section 2. So the initial injunction stated certain things, and it used this term. This term was interpreted, because it doesn't exist in the building code, by the plaintiff to allow her to put up roof, windows, siding, walls, all that stuff. We went in and said, Your Honor, this is being misinterpreted. You need to tighten this up. And what the judge did, instead of tightening it up, he expanded it. And you got to put this in context, Your Honor. Simultaneously, what's going on, and the trial judge is aware of this, simultaneously what's going on is there's a cause of action in the land court to determine whether there was an agreement to rebuild. And in context, under 183A, Section 17, these parties didn't agree to rebuild. The land court found that at trial in the following June. I think the other thing that's important, Your Honors, is that there was a lot going on behind the scenes that my client just never even knew about. And there wasn't even disclosed to the trial court. And specifically, that on August 19th of that year, the plaintiff signed a $2.5 million for a total rebuild of the entire unit. She went to the town of Nantucket. She got a building permit. She went to the HDC. And she got permission to, without my client ever knowing it, ever signing anything. None of that was disclosed to the trial judge. Your Honors, I would submit this, that the plaintiff started rebuilding on August 19th without my client's knowledge or permission. And when we informed them of our intent to exercise our rights under 183A, Section 17 on September 9th, they continued to rebuild. They never stopped rebuilding. What they did is they rebranded what they were doing. We requested...
But we're not trying this case,
I understand,
right?
Your Honor.
You're trying this case in the Superior Court. We're trying to decide if there's any issue before us, and
there is.
It seems like your primary beef is, well, the judge modified or clarified the term of weather tight. But let's assume that happened, and still, what's the harm now? Because that issue is over. You talk about, well, the judge was misled, but he wasn't misled as to the term weather tight. That's just a dispute between the parties as to what that meant. So why is there any live issue?
Because it's a wrongful injunction, Judge. It's a wrongful injunction. My client suffered an injustice. It was a wrongful injunction. It never should have been issued. And again, why it was issued, you're right. That's a matter for another time. But, Your Honors, this injunction went way beyond what was permitted under the building code and under 780 CMR. And the trial court was aware of the dispute going on in the land court. There's no way this trial judge should have allowed this to happen. What he should have done is follow the building code, order that the property either be demolished like three-step lane was or be boarded up like four-step lane was. This property was rebuilt over my client's objections and in violation of the law. What remedies we may have down the road, we'll pursue.
All right, thank you. Your time is up. Mr. Griffin.
May it please the Court. Stephen Griffin for Susan Renzulli. Your Honor, the first point I would like to clarify is that the repair work is not done. The weather-tight repair work is not even close to being done. It hasn't been able to be done because they have interfered with the preliminary injunction. By not allowing the insurance company to release the $750,000 remaining proceeds, the trust had $1 million of coverage. It was underinsured. It released $250,000 after its structural engineer came and said, "Oh, this can be rebuilt." The claim that the entire structure was destroyed is something that keeps getting has been argued for 2+ years. It's just not true. The claim that it was rebuilt is not true. The property was damaged. The roof was badly damaged, and one east-facing wall was badly damaged.
Well, what weather tightening has been done, right? This has been a couple years now. Nantucket winters are pretty cold, and so I assume there's been some work that's kind of preserved the structure.
So what happened was the contractor went in and began sealing the building up, putting a roof on. The roof has not been finished. And after the injunction, the contractor was paid the injunction allowed my client to deposit $250,000 and open a bank account, which she did, and to pay $135,000 to the contractor for the work he had already done. And it said, and he can get back to work, and he is to be paid for that work from insurance proceeds already received and to be received. His work, however, was limited to just making the structure weather-tight. And he began doing that work, and then the insurance company said, well, we're ready to give you the other $750,000, and Mr. Sullivan and his counsel said, no, we'll sue you if you do. And Mr. Sullivan would not sign the release at the insurance company, and those are direct violations of the preliminary injunction. Direct. And so when the contractor who had started the work found out the $750,000 wasn't going to be available to him, he pulled off the job. He's got a crew. He had to take his crew to other jobs. And there's been no work done on this building in over 2 years. It's sitting there. It's a blight in the historic district of the town of Nantucket. It has a roof with a rubber facing, no shingling on the side. There are holes where, my understanding is in the construction business, they pump in insulation for the interior walls, are all exposed around the building. This is still exposed to the elements. There was some interior structural work done to allow to rebuild the roof. So the roof has been rebuilt. It hasn't been finished with shingles and other things. It's covered. There's exposed plywood, all of which is going to have to be redone, and at a much more significant and a much higher cost, because the site conditions have changed dramatically, because this massive hotel 5 feet away from our building is totally rebuilt now. That was the staging area for our contractor.
So has there been no effort to kind of enforce the preliminary injunction during the single justice in this matter? Because the preliminary injunction is still intact, right? So why couldn't you go back and say, under the terms of the preliminary injunction order, we're entitled to the full amount of the proceeds going to the account, we can spend it?
Thank you. Your Honor, we filed a complaint for contempt in the Superior Court, and that was pending. It had been served, a hearing was scheduled, and that was pending when Judge Perino issued his stay of the Superior Court, of further proceedings in the Superior Court.
Pending this appeal?
No, it was pending resolution of the trial in the land court, which was resolved in September of 2023. So the stay is no longer in place in the Superior Court. The case has been assigned interdepartmentally to the same land court Justice Smith, and there is a motion pending before him now to enforce the preliminary injunction by requiring that the contractor be paid. The contractor has filed a mechanics lien action now because he hasn't been paid. He's owed several $100,000. But what the issue is, and the weather type, Judge Perino was asked to clarify what he means by weather tight. And he came back and he did that. He said it means protected from the elements and the weather, including installation of doors, windows, shingling, flashing, completion of a roof, that. We're going to button this up. And that work hasn't been done. It's been started. It's still being exposed. The costs have grown dramatically because he had to walk off the job when he wasn't getting the $750,000 wouldn't be released, as the injunction said it must be. So, we go back to what's been overlooked entirely is the basis for this injunction. The injunction was based, and Judge Perino's decision, 4-page decision, is very thorough. He looked at likelihood of success and the merits. Ms. Renzulli has a likelihood of success and a substantial likelihood of succeeding on the merits of her claims for breach of fiduciary duty by Mr. Sullivan. In fact, the land court, in September of 2023's decision, found that Mr. Sullivan did breach his violate his fiduciary duties in multiple ways, and that Ms. Renzulli did not. That everything she did was taken in the best interest of the trust, and that she acted accordingly. So that issue has been concluded after a 4-day trial. What hasn't been concluded are the damages. The client's entitled to all the attorney's fees that she's incurred because of that, et cetera, but that's still to come. But he found there was a likelihood of success as she was likely to succeed in the merits, and she was. Judge Perino found that the trust would suffer irreparable harm if this injunction is not allowed. And the irreparable harm is, this is a historic building in a nationally and locally recognized historic district. It's built in the 1840s. It has a long history of ownership. The records of the house are open to the public at the Nantucket Preservation Trust offices. There's a placard was a placard on the front of the house describing the historical nature of this house. And there are still architectural ornaments. There's a staircase that's the original railings. There are original windows. There's still original framing work throughout this building. And those are all, and my argument was, at the time, those are going to be exposed to deterioration, waste, and decay. They're open to the elements. Winter is coming. They've already been saturated by the fire department in trying to salvage this building. And Judge Perino said, we got to make this weather tight. And at that time, there was no roof on the building at all. So Judge Perino said, yes, there is irreparable harm here. And he said, and the balancing of the equities. The harm to the trust would greatly outweigh any harm to Mr. Sullivan if the injunction is allowed. Any harm to the trust if it's denied would greatly outweigh the harm to the trust if the injunction is allowed. None of that is challenged. None of that is challenged in this motion to modify. The motion to modify is nothing more than a motion for reconsideration. And which is interesting. As I was preparing for this, I noticed that in the Sullivan Volume 2 appendix, at page 72, he attaches in his appendix an email to me. And when he asks me for, at the end of the email, will you please assent, as he's required to under Rule 9, will you assent to my emergency motion for reconsideration? Well, he knows it's a motion for reconsideration. And, Your Honor, you're absolutely right. There were no changed circumstances between the date the injunction was ordered on November 18th and the date the motion to modify was filed. And the motion for modify went on, asked for a lot of things. But the fact is, and that was filed on December 16th, and it was based on 2 affidavits that are dated November 25th, not dated 25th, that were made based on site visits by these professionals on November 25th, before the contractor had gone to work. He started on the 25th and worked to December 8th. Then he was done, had to wait for structural engineering plans to get finished, and in January began the roof work. Walked off the job in March when he found out there was no more money available. And he went back to work in reliance on the preliminary injunction, in reliance that it would be enforced, and it still hasn't been enforced. There is a motion pending before Judge Smith to ask that it be enforced, but the work has not been done. this really is a motion for reconsideration, this motion to modify, and is really on all fours with a case you were involved with, Justice Meade, the Backus versus Hanna case in 2020, which is cited in my brief. Same situation. Somebody sought to modify a preliminary injunction. It was denied. An appeal was taken, and the appeals court, Justice Meade, you recognized the line of cases with Manousis v. Sarkis, and I think it's McGrath versus McGrath, that a literal reading would eviscerate the general rule disfavoring piecemeal appeals by allowing artful pleaders with potentially perpetual opportunities to appeal orders that continue, modify, or refuse to dissolve or modify injunctions. And what the court found in that case was exactly what's happened in this case, and that the appellant was not permitted to do so here. When the time from which the filing of the initial...
Do you think it matters at all that if the judge materially changed the terms of the preliminary injunction, do you think that matters at all in terms of failing to file the notice of appeal?
That's a hypothetical situation because there was no change to the terms. The motion was denied in its entirety, yet and the judge took the opportunity, as he says, to clarify, since there's some dispute about what weather-tight means. And he gave his clarification. He asked for a clarification, and he got it. He doesn't like it. And that's what this is all about. And they have refused to recognize it and made all sorts of personal and ad hominem attacks about how that weather-tight word got into his decision. He used the dictionary. Weather-tight, he says, weather-tight is not a real word. It doesn't exist. It does exist. I've done searches in Massachusetts case law, in the statutes. There's plenty of references to weather-tight. It was referred to by in a letter sent by the Historic District Commission to the owners of this property saying, you need to make this weather-tight, and citing the town regulations. So, and he claims he has a number, he also stated that he claims he has a number of claims against Ms. RENZULLI. Your Honor, it's been 2.5 years since this case was filed in the Superior Court. Still hasn't filed an answer. He has no counterclaims against Ms. RENZULLI in the Superior Court. Your Honor, we believe this is a frivolous appeal. The single justice seemed to suggest it was as well, but there was no appeal of the preliminary injunction. The motion to modify was appealed. The notice of appeal says that only, and there's been no change in circumstances. There were no change in circumstances on the ground between November 18th of 2022 and December 16th of 2022 when the motion to modify was filed. Thank you.
Thank you. Thank you both. We'll take that under advisement. We're going to take a short recess.
All rise. Rise. This court is now open. Please be seated.
Our next case is 24P973, Rangeway Owners versus Billerica Developers. Mr. Frey.
Good morning, Your Honors. May it please the Court. My name is Kelly Frey, and I represent Appellant Billerica Developers, LLC. Your Honors, Billerica asked the Court to reverse the decision below for either of two reasons. First, the trial court erred in denying Billerica's motion for judgment on the pleadings because the sewer right that Rangeway purported to exercise unambiguously states that it must be exercised by curriculum associates for the purpose of connecting the curriculum associates business to the public sewer service. Second, and alternatively, if the court does not give effect to those words in Section 2 of the party's contract, then the court should still reverse because the pleadings do not establish all facts necessary to find that Rangeway did, in fact, exercise Section 2 in accordance with its terms. Indeed, Rangeway has not even identified what its future uses of its property would be that would be connected to the sewer line, and thus there's no way of knowing whether applicable government authorities would approve the connection as is required under Section 2, and there's no way of knowing whether Rangeway's anticipated uses would overburden the sewer improvements on Billerica's land and cause them to collapse. If the court finds that these or any other unanswered factual questions from the pleading must be resolved before the court can make a determination that Rangeway did exercise the provision in accordance with its terms, then the court should reverse and remand for further proceedings.
You didn't raise that second argument until your motion for reconsideration, correct?
I'm sorry.
You didn't raise the second argument about applicable government authorities until your motion for reconsideration, and the judge didn't consider it. Isn't that true?
No, Your Honor. We raised the fact that there are the second issue is that there are multiple. That's one of many factual issues that's unresolved. We raised the fact that page 180 to 181 of the record appendix at the hearing on the motion for judgment on the pleadings, we raised the fact that there are multiple unresolved issues that even if the court denies Billerica's motion for judgment on the pleadings, it cannot grant Rangeway's motion for judgment on the pleadings because there were several unresolved issues, including the fact that Rangeway hasn't even identified what uses it's going to connect to the sewer pipe.
Right, but the issue about the applicable government authorities not approving the extension and connection, you didn't make that argument until your motion for reconsideration.
It was raised explicitly in the motion for consideration. Billerica's primary argument was that Rangeway cannot establish that it exercised Section 2 in accordance with its terms. Admittedly, Your Honor, yes, the primary portions of Section 2 that were the primary focus of the motion for judgment on the pleading briefing were the requirement that it be curriculum associates who exercises and that it be exercised for the purpose of the curriculum associates business. And the government approvals issue was raised. It's raised in the pleadings that Rangeway didn't know that that Rangeway had not identified which uses it would have. We actually, in our counterclaim, we allege that we asked them to identify that information. They refused, but it was specifically argued, I guess, Your Honor, in the motion for reconsideration.
How would they get government approval when it's Billerica's land?
Your Honor, that's they can't get government approval, Your Honor, because they're not the one parties.
So then it's not before.
I'm sorry?
So then it's not before. They don't need it as a precondition.
That's an unresolved factual question, right? They've claimed that without support in their pleadings that they can't get government approvals because it's our land. There's no facts to support that in the record. They haven't offered any facts to support that in the record.
They can go to the local government and ask for permission to do something on someone else's land?
They haven't done so. They haven't even tried to do so, Your Honor. And so when they tried to exercise the extension right without even applying for a permit or asking the town to approve, they haven't even attempted to comply with this requirement in Section 2 of the agreement.
So in the first argument, you rely on the language in the provision titled sewer extension, and there you kind of make a negative implication argument that the language refers to garden homes or its designee and assignee or successors in title, but doesn't do that with respect to curriculum associates, correct? That's kind of your main argument on the...
No, Your Honor. Actually, our main argument is that Section 2 says that the option can be exercised by curriculum associates for the curriculum associates business. Curriculum associates business is a defined term within Section 2, and it's defined in the contract to mean the publishing business that curriculum associates operated on its land. And we argue that the fact that the parties capitalized and defined the words curriculum associates business in their contract leaves no ambiguity as to what their intent was. Their intent was for this provision to be exercised for one purpose, the purpose stated therein.
Okay, so what is your argument on the other provisions, the one titled successors and assigns bound, and the other provision, easements run with land? Those both talk about designees or successors and agents. So why aren't those provisions, why was it error for the judge to rely on those provisions in concluding that the promises in Exhibit D run with the land?
Answering those questions in turn, starting with Section 4, it was error for the court to rely on those because Section 4 says that it applies to only one party's successors, Aspen Apartments, Billerica's predecessors. It only applies to one party's successors. It does not say that that the benefits of the Exhibit D agreement shall be enjoyed or enforceable by curriculum associate successors. It says only that we, as Billerica, and we don't dispute this, that if curriculum associates came to us, we, as the successor to Aspen Apartments, would need to honor the sewer provision. That's what Section 4 says. We comply with it. What we've objected to, and we asked the court to reverse on, is that we're not going to do something that Section 4 says that we don't have to do, which is recognize that the recognized rangeways exercise the right as a successor.
So the easements run with the land provision says, shall be binding on and in order to the benefit of curriculum associates in Aspen Apartments or its designee that has taken title to the Aspen Apartments land and their respective successors and assigns.
If I may just finish my answer on Section 4, and I will answer that because I do have a good answer for that.
Okay.
I just wanted to say that language in Section 4 is entirely consistent with the sewer extension provision itself in Section 2. In that provision in Section 2, it says that if garden homes or successors or assigns develop this apartment complex, then the successors or assigns will need to honor the sewer extension promise to curriculum associates. Section 2 does not say, just like Section 4 of the easement agreement, does not say that curriculum associates or its successors can exercise this right for the benefit of the successor's business. Those facts are almost identical to the contractual provision at issue in the Brand case that we cite in our case. It was a land court case that was affirmed by Rule 128 decision by this court. There was a deed that was granted from a seller of a property, and then an attached agreement that was recorded along with the deed. And it said that if the buyer breaks up the land and sells a part of it, then the buyer would have to pay back to the seller or its successors a portion of the proceeds. The court found that because the parties said that one party's successor, they used language saying that the agreement will be binding on one party's successors, but not the other. That showed the parties knew how to use the right language when they intended for a contract to apply to one party's successors, and their choice to abstain from using that for the other party is clear and unambiguous evidence of their intent that they did not intend for it to inure to the benefit of the other party's successors. But thank you for indulging me, Your Honor.
It's the good part. Easements run with the land.
Yes. Going to Section 5 of the easement agreement, Your Honor. Yes. So the Section 5 of the easement agreement says that the rights, duties, easements, and lowercase a agreements herein contained shall run with the land. So that does not. That language tells us two things. First, the A is not capitalized. Prior, in Section 4 of the agreement attached as Exhibit D and the easement agreement itself are collectively defined as capital A agreements. If the parties intended for this provision, Section 5, to apply to both, it would have been easy for them to capitalize agreements. They didn't do that here. They said the agreements herein contained, meaning herein within the easement agreements itself. These are the ones that will run with the land, not the ones that are specified or elsewhere contained in the attachment as Exhibit D.
Can I ask you on page 33 of your brief, you said that Garden Homes couldn't possibly grant the easement to curriculum, only Aspen Apartments could, not Garden Homes, as the owner of the land.
Yes.
But they're both defined as, this is in Record Appendix 33, they're both defined as K&K developers with the same address in New Jersey.
One is K&K Developer Inc., one is K&K Developers Corp., Your Honor. The distinction between the two is further clarified at RA 50, Record Appendix page 50. That's a portion of the, the first page of the Exhibit D agreement. It describes.
There's a difference between Inc. and corporation?
Yes, because one property is the landowner, the other property is an affiliated entity that was meant to construct and operate the apartment complex. So the entity that entered into Exhibit D and purportedly Rangeway says granted an easement to the property does not own the property. The property was owned by its affiliated entity, the Aspen Apartments entity. But going back to the language in Section 2, Your Honor, the language says, it couldn't be clear. I mean, it says that the option may be exercised so that Curriculum Associates can connect the Curriculum Associates business to the Public Sewer Service. Curriculum Associates business is defined term, the publishing business on the property. Rangeway's pleading admits that it, not Curriculum Associates, was the one who made the election to exercise the sewer option, and also says that it is not exercising the option in order to connect the Curriculum Associates business to the Public Sewer Service. The decision below must be reversed unless this court determines that those words in the contract are meaningless. And we urge the court not to do so because under rules of contractual interpretation, the court is to construe words so as to give them meaning whenever possible and not treat language as superfluous. The defined term Curriculum Associates business would be entirely superfluous unless it's meant to, given the meaning that's intended to affect, that the Curriculum Associates business is the only use that can be connected to the sewer through the exercise of this provision.
You know what, though, let me just ask you this, because I'm trying to put myself in the position of Curriculum Associates going back in time. And if to read it the way you want it all read, if I were Curriculum Associates, in this contract was limited to me, my entity, I think before I conveyed the property, I'd move heaven and earth to make sure that I got this sewer hookup to enhance the value of my property before I sold it, right? Like why would you just, if it was a contract that was just limited to me, I would make sure I exercise those rights to enhance the value of that asset before I sold it. Like, why would you sell it and just say, oh, okay, well, geez, we had a right to exercise this, but so what, we'll walk away from it. That doesn't seem logical to me.
Well, the appellate record is silent on what there's nothing in the pleadings to alleging what Curriculum Associates' motivations were or intent was in failing to exercise. It's undisputed. They never did exercise it before they sold it.
Yeah, but it would be an odd thing to not exercise if you have that right that would clearly increase the value of your property, and then you just walk away. It's like, money on the table and you just walk away.
Well, I mean, the court need not look to the party's intent because the words are there in the agreement. They say for the Curriculum Associates business. As to why they're there, it's clear and unambiguous. So The extrinsic evidence we submit shouldn't be something that is considered by the court, but if it is, the one area where there is extrinsic evidence of what Curriculum Associates' intentions were with respect to this provision is in the affidavit of Connor Nagel, where when Curriculum Associates signed this agreement in 2008, and then years later, when it expanded the Curriculum Associates business to incorporate more square footage, it came to Billerica to confirm, hey, we've expanded. We've changed what the Curriculum Associates business is. Can you confirm that this isn't going to overburden your system and you're still going to honor the sewer provision if we ever intend to elect it? And we did. Billerica talked to its engineer to make sure that it wouldn't overburden. And they said, yeah, sure, you can make this minor expansion.
We're going to have to leave it there, Mr. Frey. Your time is up, Mr. Frey. Mr. Perry.
Thank you. Good morning, Your Honors. My name is Timothy Perry. I represent Rangeway owners. May it please the court. I think what we have here is a pretty straightforward contract that and the trial court applied the terms of that contract in a reasonable and practical manner, and with respect, I think there was no error. Underlying my brother's argument is this notion that these are two completely separate agreements that need to be looked at separately, and if you parse them out in that way and apply only terms to one and not the other, then his argument holds water. Problem with that, as the trial court found, is that this was, by its express terms, an integrated agreement, starting with the fact that it was recorded at the registry as a single document, and as the trial court pointed out, it could not have been recorded as two separate documents for one simple reason, and that was that the Exhibit D, which is incorporated into the easement agreement, is not executed fully by the parties. It's initialed by my client's predecessor, and the registry won't record a document like that, and the statute of frauds won't allow a document like that that affects the rights in land. So the trial court was correct right from the very start in saying that these are clearly integrated agreements. And as I pointed out and as the court adopted, each of the whereas clauses specifically references and incorporates those four exhibits, including Exhibit D. And Exhibit D, importantly, was the consideration, and it says right in that therefore clause on page 2 of the easement agreement, that's the consideration that my brother's predecessor was giving to my client's predecessor. In other words, the easement agreement, the body of the main agreement, has my client's predecessor giving easement rights to K&K. The only consideration for that was Exhibit D, and that's what the therefore clause says. And so if Exhibit D is not incorporated into the easement agreement, then there's no consideration that K&K was giving to my client's predecessor.
But the key question seems to be, was your client's predecessor, did the benefits that went to that company, did it flow to the successors as well, right? And there seems to be some different language at issue here, right? And they seem to have a decent point that in certain provisions, successors refers to Garden Homes and their successors, but not to Curriculum Associates and its successors, right? So how do we kind of reconcile that difference in the language in those provisions?
I think that it was appropriately reconciled by the trial court, and I think this court and the SJC has given direction on how an agreement like this is supposed to be applied in order to give all of its terms effect and to be read in a reasonable and practical manner. And I say that not to state obvious black letter law, but because if you just parse these sections, like Section 4 and Section 5, out and then leave Exhibit D, stranded on the side, then you're not reading a document. With respect, you wouldn't be reading the document as one harmonious document, and it wouldn't make sense. And this court and all the courts that have come before us have said that's not what you're supposed to do. And so to get more specific on that, Exhibit 4 and, Sections 4 and 5D, as you went over, would give, first of all, state that these provisions all run with the land, and they do specifically reference Exhibit D, and they say that they inure to the benefit of successors and assigns. And so just to say, okay, now we disregard that and jump to Exhibit D, and there's a definition of curriculum associates business, and so only that business could ever seek to enforce this agreement. We argue below, and we'll argue here again, that that argument's a red herring in our view, again, respectfully, for a few reasons. Number one, as I just said, it would disregard Sections 4 and 5D of the main agreement. But number two, curriculum associates is still there. The business is still there. They're a tenant at the property. And so this sewer hookup is still for their benefit. That was never a real issue to be raised. And then third, if that position was true and that only the easement could be sought to help the curriculum associates business, then naturally that same Exhibit D would have a removal and restoration clause. In other words, if it's only for curriculum associates, then they could have put it in and then sold the property, as Your Honor pointed out. That increases the value of the property. But a new owner comes in, and under their reading of the contract, we would have to remove the sewer because it's only to benefit the curriculum associates business. I think that would make absolutely no sense under these provisions as they stand. And the only way it would make sense, again, is if there would be a provision in this agreement that said once curriculum associates business stops using the premises, the easement is gone and you have to remove the sewer extension. For those reasons, Your Honor, I think we've set it forth in the record. I think the court below really spent a lot of time reading how those provisions were integrated and related to one another. He did it at a oral hearing. He did it in a written decision, and then he also considered the motion for reconsideration and stated that he had looked at his own decision and had drilled down and determined that he hadn't made any manifest error of law, and he still said that this was the reading that gave most effect to the terms of the entire agreement. So for those reasons, Your Honors, we think, again, it's a straightforward case with an integrated contract.
Thank you.
Thank you, Your Honor.
Before you can sit down.
Oh, sorry.
I just have some advice for the future. Although you comported yourself properly today, ad hominem attacks on opposing counsel and on a Superior Court judge or petty carping about a typographical error in his decision are not effective appellate tools. So please apply those principles in the future. Thank you. We'll take it under consideration. The next case, I'm sorry. Yeah.